So far, we've explored a number of points in these criminal law classes on Actus Reus, and thank you for watching all of them. Let me remind you of the 8 points we have covered by way of a quick summary. Point 1. The criminal liability formula for most criminal offences is Actus Reus plus mens rea minus a defence equals criminal liability. Point 2. The criminal liability formula for strict liability offences is Actus Reus minus a defence equals criminal liability. Point 3. There are 3 different types of crimes. Conduct crimes, for example, battery. State of affair crimes, for example, Section 4.2 of the Road Traffic Act, being in charge of a motor vehicle under the influence of drink and drugs. And result crimes, for example, murder and manslaughter. Point 4. The general rule on omissions is that there is no criminal liability for a failure to act unless a duty arises from one of the 5 exceptions where a failure to act can give rise to criminal liability. Let me go through those exceptions. 1. A statutory duty, for example, Section 170 of the Road Traffic Act, failing to stop and report an accident. 2. A contractual duty, as per the case of R versus Pitwood. 3. A special and close relationship, as per the case of Gibbons and Proctor. 4. A duty to avert a danger created, as per the case of R versus Miller. And 5. A duty arising out of a voluntary assumption of care for another, as per the case of Stones and Dobbinson. Point 5. For result crimes, the prosecution must prove or establish both factual and legal causation. Causation is an issue in situations where causation is not obvious and clear. Here, the accused may blame someone else or something else or an intervening act for causing the result. Point 6. The prosecution must establish and prove factual causation. The test for factual causation is the but-for test, as per the case of R versus White. The question for the jury is, would the result have occurred but for in the absence of the defendant's actions? If the answer is yes, the defendant is not criminally liable. Point 7. The prosecution must also establish and prove legal causation, that the culpable act, so for example the punch, is the substantial and operating cause of the prohibited consequence. The courts have developed 5 rules or principles, and not all of them apply in a given scenario. But let me go through them. 1. The result must be attributed to the culpable act, as per the case of R versus Dalloway. 2. The culpable act must be more than a minimal cause of the consequence, as per the case of R versus Paget. 3. The culpable act need not be the sole cause of the consequence, as per the case of R versus Benge. 4. The accused must take the victim as they find them, also known as the thin skull rule, as per the case of R versus Blower and R versus Haywood. And 5. The chain of causation must not be broken by a new and intervening act. And point 8, and remember, various tests apply to various situations as developed by case law. So in escape cases, the relevant case was whether the victim's response was a proportionate response to the threat posed, as per the case of R versus Roberts. In suicide cases, the rule is that voluntary euthanasia does not necessarily break the chain of causation, and the question was whether it was reasonably foreseeable that the victim would commit suicide as a result of their injuries, as per the case of R versus Wallace. In delayed ambulance cases, the test is, was the ambulance driver's actions
free, deliberate and informed?
In police shootout cases where a hostage of a defendant dies from a police shot, the test is again whether the actions of the police officer was free, deliberate and informed, as per the case of R versus Paget. In medical negligence cases, the test to be applied where the intervening act may arise from poor and negligent medical treatment is, if the medical negligent treatment is the immediate cause of the victim's death, it should not break the chain of causation unless it is so independent of the defendant's acts and so potent in causing death that it makes the contributions made by the defendant's acts insignificant, as per the case of R versus Cheshire. And the test to be applied where the intervening act is from a so-called act of God is, the chain of causation will only be broken if the intervening act of God is unforeseeable to the reasonable person and unforeseeable to the defendant. Now, in the next series of criminal law classes, I will be exploring mens rea or guilty states of mind and focus on intention and recklessness. I will also explore negligence and strict liability offences. I really hope you find these criminal law classes interesting and useful. Please follow and subscribe for more, and feel free to comment.